So, hello, my name is Marcus Gomez. I'm an attorney. I've been practicing for 44 years, and I'm going to discuss the issue in family law of divorces and separations. First of all, I want to say that I'm sorry to hear that you're inquiring about a divorce or legal separation. These are very difficult times, of course, for everybody. For you, your spouse, your children, your family, and your employees or business associates. But the idea here at our law firm is to make it as comfortable for you as we possibly can. So we'll start out with a divorce. What is a divorce? In California, it's called a dissolution of marriage, and most often is accomplished by asserting that you have irreconcilable differences with your spouse. That means you guys can't get along. Maybe you've been to counseling. Maybe you've been to the priest, you tried different things and they haven't worked. So you're now at this point. Do you want to get divorced? Well, it depends on what you expect at the end of the day. Some people want what's called a legal separation. A legal separation stops short of dissolving your marriage, but it acts as a notice to the world that you are no longer combining your credit with the other party. So, for example, if you are purchasing a home or getting credit and you have a legal separation on file, the lending party should know or is being warned that they cannot count on your spouse or you for your credit because you are legally separated. Now, in either situation, there are several topics, and the most common ones are, first of all, you start out with the kids. If you have children, the court wants to give custody of the children or time with the children 50-50, if possible. The policy of the law of the state of California is that it is in the best interest of the children to have equal and maximum time with both parents. Now, this cannot always be the case. It may be that one person works a lot of hours and another parent is home a lot. And so there may not be an exact 50-50 division or shared time of custody of the children. But the court's trying to accommodate the parties the best that they can. The court doesn't look at what the needs of the parents are. The court looks at what the needs of the children are. So when you go into court, and if you come into court and you tell a judge, well, my children have to be with me, you're going to get shut down pretty quickly. The judge is going to correct you and say, our children. I hear it all the time. I advise clients to practice before they walk into the courtroom. It's our children, and you have to be ready to explain why your parental plan should be the one that the court follows. The next issue that usually arises is support. Child support is obligatory under the state of California. Parents are obligated to support their children. And in California, that's done by way of a program in which the court puts in the parties' respective incomes, some of their expenses, not all. Some of the hardship factors, do they have children from another relationship, and those sort of items, and then makes a calculation as to how much the supporting party should pay to the supported party. Honestly, the judges don't care if you live in a car or not, so your expenses really don't mean anything. What's mostly meaningful is how much money you make for both parties and how much timeshare you have. And then some critical other factors, including, do you have children from another relationship? Do you have mandatory deductions from your income? Who's paying for health insurance? That sort of thing. So now we've gotten to the kids. The next item would be spousal support. Now, spousal support is made up of two types. The first type of spousal support is temporary spousal support. After the breakup of a marriage, things get pretty rough. And there has to be a safety net for the party earning less money. So once again, the courts will use a program called the Dissomaster, in most cases, to calculate the amount of spousal support. And if that person is also getting child support, give credit to the supporting party for that. In other words, you'll get more child support than you will spousal support because the kids count the most. That's temporary support, and usually that's a little bit higher at the outset, again, because it's safety net support. The second type of support is long-term support, and for that, the courts are forbidden from using the Dissomaster. Instead, the calculation takes into consideration a number of other factors. How long have the parties been married? Did one party help the other get an education? What was the standard of living during marriage? Was there any domestic violence involved during the marriage? And numerous other factors to take into consideration when determining what would be fair to protect the supported party at the end of the marriage. Now, you can only qualify for long-term support if you've been married for 10 years. If you've been married for less than 10 years, generally the courts will cap you out at about half the time that you were married. So, for example, if you're married for 8 years, you're going to get only 4 years of long-term support. If you were married for 6 years, you're only going to get 3, and so on. So you have to be married for at least 10 years to get long-term support. A caveat or caution that I give to clients, especially the supporting husbands, is that they have to be careful because temporary support can last until that whole issue is resolved and you go to trial. I've seen situations where attorneys have fought over temporary support, and 5 years later, the attorney is ready for trial and he says, "Judge, I want you to terminate support. They were only married for 6 years. She should only get 3 years support. She's been getting it for 5. And the judge will say, "Well, that's tough luck because that was temporary support. And you guys delayed the case. And so now we're going to talk about long-term support, if any." So in that case, the strategy is to get into court as soon as possible. The next item or big ticket item would be your property. The rule in California is that community property is divided 50-50 between the parties. Community property is generally defined as property that is acquired during the marriage. Separate property is defined as property one acquires before marriage, after separation, or from an outside party as a gift or an inheritance. The courts look at a division of your community property as if they're dividing a business. So it's businesslike, it's not emotional. It's a straight down the line division as best a court can do it. The judge is not going to take a chainsaw to a car and say, "You take this half and you take the other half." The court is going to try to balance the properties as best as it can and come up with a 50-50 solution as near as practical. That includes your house, that includes your business, your cars, your furniture, your retirements, everything else that you acquired during the time that you were married. Once you separate, then whatever property you acquire is generally seen as your separate property, unless it originates from a community property source. So, for example, if you have an investment property and you're renting it out, although you're separated, that house is community property. And so the profits from that community property home would also be community property. But if you're working and you go buy a lotto ticket and you hit big, that would be your separate property because you are now separated. Data separation has meaningful significance in a lot of areas and can mean different things. The other issues that are usually come up involve restraining orders. When you file for divorce, there is automatically a restraining order against both parties from getting rid of community property. You cannot sell or give away any community property without first letting the other party know and getting their agreement to do that. Otherwise, you actually can be punished by the court and given sanctions. There are other issues, but those are the ones in general. The last one would be attorney's fees. And that's the one that comes up very often. The law is established that a person in a divorce case is entitled to representation as best can be done under the circumstances. So if one party makes a lot of money and the other party makes very little money, the party making the more money has to contribute to the legal defense of the other party. This most often is a high-earning husband who basically is paying all the bills, and the wife who's staying at home doesn't have any money saved up from an attorney. She can get an attorney and ask that her husband pay her attorney's own bills. How long will it take before you get divorced? Well, the process starts when you initiate the filing of your first paper, your petition. You have to pay a court fee for that, and you have to serve the other person with a copy of that petition. The other party has 30 days to respond. 6 months from the day that the one party gets the paper in their hand is when you can first get a divorce. California has a 6-month waiting period. So once the 6 months are up, that's when you can get a divorce. Divorces normally, though, in LA County, Orange County, San Bernardino, and Riverside counties, take about a year, more or less, to get to a final judgment, which is a final order of the court.
Mr. Gomez, how long does it typically take to get a divorce?
It typically takes approximately 1 year in the Los Angeles, Orange, San Bernardino, and Riverside counties. That's because the courts are handling many other matters, criminal and civil matters, and there are only so many judges that can handle the cases. Now, you can actually get a divorce technically within 6 months after serving the divorce paper on the other party. So 6 months after that other person gets the paper in their hand, you can technically get a divorce. If you do it right, you might be able to get the paperwork done and you'll get the divorce done at least within 6 months. But generally, it takes about a year.
Do I need a lawyer to file for divorce?
No, you do not need a lawyer to file for divorce. It is not a requirement, but it is almost foolish not to have an attorney if you have children and there's a disagreement about who has the kids, if you need support, child support or spouse support, and if you have any property. Many people think that they can handle divorce on their own and come to us late in the game and say, I went to court and I got clobbered. What happened? I don't even remember what occurred. The judge didn't listen to me. So here at the Gomez Law Firm, what we strive to do is explain the process to you, make sure that you have a strategy, and that we do the things necessary to win the case for you.
What happens to our debts after divorce?
So debts can be either community property debts or separate property debts. Community property debts are debts that you acquired as a couple during your marriage. Separate property debts are debts that you acquired before you were married or after you separated. With regards to separate property debts, that person who has the debt, owns the debt, has to pay for it if it's separate property. But with regards to community property debts, those debts are supposed to be divided equally.
Can I get a divorce if my spouse refuses to sign?
Yes, you can get a divorce even if your spouse does not want a divorce. In California, you have an absolute right to a divorce, and you can simply allege that you have irreconcilable differences, meaning you can't get along. And so it's a very low burden of proof. there is not really any other way for the other party to object to that.
What if my spouse is hiding assets during the divorce?
That is very common. And there is a way to rectify that. First of all, the parties in a divorce case have a fiduciary relationship to each other. In other words, the husband has a responsibility to tell the wife what assets they have, where they're at, and what they consist of. The wife has the same responsibility to the husband. So the parties are compelled by the law to let each other know what type of properties they have. If one party is hiding the other assets, then they'll be hiding them from their paperwork that is required by the court, which are called declarations of disclosure. And if a party does not disclose their property, they can be penalized by that. The penalties can be for negligently hiding property, 50%, or if you are intentionally hiding property, you can lose the entire property, 100%, and be responsible for attorney's fees and sanctions. There's different ways to figure out if a person is hiding property. You can subpoena the records from a bank. You can hire a forensic expert to find out whether or not funds have been misappropriated. So those are the sort of things that we can do for you.
How does legal separation differ from divorce?
A divorce is a final act in which there is a judgment saying that the marriage is dissolved. A legal separation is a notice to the world that the parties are no longer living together as husband and wife, but their marriage has not been dissolved yet. And the benefit of a legal separation is that it is notice to creditors. For example, the wife would say, hey, don't give a loan to my husband and include me on it because we're separated. So that is basically the purpose of a separation.
Can a child choose which parent to live with?
The guidance for child custody is the California law saying that children should have frequent and continuing contact with both parents. That is the policy of the law. That means that even if one parent is a bonehead, it's okay for the child to be with that parent because the child knows they have two parents that care enough about them to see them and be there for them. So a child doesn't really have much say in the matter until they turn 14 years old. At 14 years old, a child is presumed to be competent to express which parent they want to live with. But although some courts permit children to testify, that is in fact rare. Mostly what happens in that type of case is that the court will hear from the child through either a minors counsel, wherein an attorney is appointed by the court, paid for by the parents or the county, to represent the children's interest in custody matters. Or there is what's called the PPAs, which is a parental plan assessment. And in that case, the parents and the children are interviewed by a social worker who conducts a study, either a half-day study or a full-day study, talks to the parents, talks to the family, checks up on their school records, their medical records, and then makes a recommendation to the judge.
Are there any other factors that influence custody decisions that we haven't spoken about?
Yes, domestic violence. If one party is found guilty of domestic violence, they are presumed to be an unfit parent and can only go back to a normal relationship with their children by taking anger management courses, maybe some therapy, counseling with the children. So what happens is, if a parent is found to have been involved in domestic violence and the court feels that it is in the best interest of the children not to be with that parent because there is already a presumption, then the court will probably order what's called monitored visits for the offending party. Those monitored visits will go on until the offending party has rehabilitated themselves and shown that they are trustworthy and that the children are not in danger when they're with the offending party. That process is called the reunification process. Reunification means that one party can be reunified with their children after they've gone through all the required steps, domestic violence classes, counseling, and what other conditions are required by the court.
How can I modify a custody order?
Prior to a final judgment, a party can file a request to modify child custody. In that matter, what you have to do is fill out the paperwork and explain to the court why you want to modify custody. Now, modification of custody presumes that there already is an order. And what you're saying is that you want to modify it because there's something wrong with it or there's been a change in circumstances. If there is, in fact, a change in circumstances, for example, one party has been missing their share time, or one party doesn't show up for visits, or something similar to that, then that might require an adjustment or a tweaking of the custody arrangement. Once the paperwork is filed, approximately 30 to 45 days later, you will have a hearing in front of the judge. Prior to the hearing with the judge, the parents will be required to go to mediation. There is mediation normally online, and the parties have to participate with a person who has a license in family, as a family clinician, a social worker, and they try to work out a parental plan. If the social worker is not able to work out a modification, a voluntary modification with the parties, then the matter goes to the judge. The counties treat these things differently. In Los Angeles County, there are no recommendations made by the family counselor or the social worker. They simply say mediation occurred or didn't occur, and that's the report they send to the judge. However, in San Bernardino or Riverside counties, the social workers will actually write a report out and make recommendations, and the judges will lean on these recommendations. So it's important to know the difference between the counties as to what are the requirements and what are the different procedures for a modification. At the modification hearing, the court normally will only look at your paperwork. So it's really important that your initial paperwork include all the things that you think are important. For example, it may be that one child has special educational needs and they need an IEP and the other parent doesn't agree. So you want to get that paperwork in so the judge can actually look at it. Or if your parents that are on what's called the Talking Parent app and there's a disagreement, using the Talking Parent app, the judge can look and see their conversations and find out if one person is being unrealistic as opposed to the other. So the court will normally look at the paperwork. In some special cases, the court will say, hey, you need a minors counsel or you need a parental assessment. In other situations, the court will provide you with an evidentiary hearing, at which time you can have witnesses and much more evidence, maybe even have an expert like a doctor or a teacher testify. So there's a lot of variations on that. The request for a modification of an order is not a simple task.
What can happen if my ex violates a custody agreement?
A custody agreement will usually, after 15 days more or less, turn into a court order. The judge will look at the custody agreement, and the judge, if they think the custody agreement looks reasonable, will sign off on it. Now that's an order. And disobeying court orders is contempt of court. So if you do not follow the court's orders, you're in contempt of court. And the penalties can be that the judge can modify the custody arrangement and give one parent more time or take away your time with the children, or the other party can file what's called an order to show cause rate contempt, in which case you can be penalized financially or in very serious cases suffer the consequences of jail time.
Can a parent move out of state with a child?
A parent can move out of state with another child only with the permission of the other parent. It is rather difficult to move a child out of state without the other parent's approval. The reason for that, again, is because the state of California wants the child to have as much parenting time with both parents. Those build healthier relationships. And so what the court wants to do is keep the child in the local area, in the schools they've been going to, with the family, and in their neighborhood. If a parent wants to move away, they have to make a request for that, and that's determined usually by what's called the Lamouche case, wherein you have to prove that it is necessary for you to move out of state. Very difficult to do. However, if one parent is not visiting much anyways, or has been lax, or broken the rules, hasn't followed through on visitation or custody time, then you might have a better chance because the court will say, well, you're not seeing the kids anyways. If the other parent moves out of state, the kids can come over and be with you during the summer or during the spring break or during the other holidays, and something can be worked out. Otherwise, you cannot simply just say, you know what, I got a better job offer in another state. That's not a good reason to move the children.
How is visitation scheduled?
Yes, so the first question that the judge is going to ask is, why not 50-50? 50-50 arrangements depend on the age of the children. When the children are small, they cannot be away from the other parent for a long time. So most often, if you have a 50-50 schedule, that would be like a 2-2-3 schedule. Monday and Tuesday with one parent, Wednesday and Thursday with another parent, and back to the other parent Friday, Saturday, and Sunday. And then you flip it. In a situation where the children are like teenagers, then a week on and a week off schedule is more appropriate. So 50-50 schedules are what the court looks to in the first place. However, if that cannot be accomplished because one party works a lot of hours or for some other reason is unavailable, or if there's been issues of domestic violence or something else going on, or even the needs of the children. For example, if one child has a autism or something like that, and one parent is more attuned to them, that is, they've been to the doctors more often, they've been more trained in taking care of their child that has autism, then the courts will take that into consideration. So the court wants to do 50-50. If not, then the court will work out something that is in the best interest of the children, not the parents.
So with the 50-50, let's say you have one parent one week, one parent the other week, one parent, like parents are doing things to spite the other parent, right? Like what kind of can happen in that situation?
So the regular order of the court is that the parents are not to make disparaging comments about the other parent. That's a standard order. And of course, proving it is something else, you know. But parents are not to speak negatively about the other parent. Now, as children get older, they'll tell the counselor or they'll tell the court-appointed attorney, or there will be witnesses who will hear that. And that is subject to a punishment by the court. The court will reduce the time of the parent who's making the disparaging remarks, or find some other remedy.
What are my rights as a non-custodial parent?
If you are the non-custodial parent, that means that term sort of fluctuates because really the term is you have shared custody or you can have joint legal custody or physical custody, or one parent can have primary physical custody and the other party can have secondary physical custody. So those terms fluctuate. The real thing is that's important is what is the percentage of time that a parent has with the children. And if one parent is the so-called custodial parent, they have an obligation to share the children with the other parent. And so a lot of times you'll find that the non-custodial parent, even though they don't have the children with them most of the time, or maybe very little, when they are available, and if it is reasonable, the parent with custody should make the kids available to the other parent. And the court will look at whether or not you're being reasonable. Remember, the policy of the law of the state of California is that the children are to have frequent and continuing contact with both parents.
How is child support calculated?
Child support in California is normally calculated by using a program which takes into consideration the number of children, the number of exemptions that the parents claim, the gross, not net, income, and then other types of income, whether they're tax exempt or not. And then we'll deduct from there whether or not the person is paying support in another matter or has other children or has mandatory deductions like union deductions, health care deductions, and that sort of thing. What the program does not take into consideration is how much you pay for rent or how much food you eat or anything else. It's normally said that as far as the state of California is concerned, they don't care if one parent is living in a car or not. What's primary is the obligation to support your children. So it can be really brutal for a parent who is the supporting party when he gets the number, especially from the County of Los Angeles. And so it's important to present the full picture and to properly present your financial status to the court so that you don't overpay. I guess one of the most meaningful factors would be the time spent with the children. And if you're 50-50, you're still going to pay some support if you make a lot more money, but it'll be less.
Can it be modified after the fact?
Yes. Child support can be modified. The parties cannot agree to waive support. That right does not belong to them. That right belongs to the children. They can modify support to whatever is reasonable, and the court will normally go along with it. It may be that one party is promising to pay the car bill for another party or something like that. And so they both agree that support can be reduced. But absent that, if you want to modify support, there should be a change in circumstances, including one party making more money or the other party all of a sudden doesn't have enough money. They've lost a job. They have become ill or injured and aren't making the money that they should. So yes, child support can always be modified.
What if my ex don't pay?
If the party who is ordered to pay support does not pay support, he can be subject to penalties because a support order is a court order. Violating a court order that is not paying support is punishable by civil fines as well as jail time. So you can be subject to contempt, attorney's fees, and fines. Also, by the way, child support that is unpaid or is in arrears has interest tapped on top of it. And so it's pretty common to find fathers who have not paid and then one day decide they want to modify support, but they haven't made the move yet. That time for them to complain about support in the past has already run. That interest on that has already accumulated. They can only change support from the time that they file the request for modification. Prior to that, you've lost all your opportunities. That is how strong the policy is with regards to the support of the children, that you don't get a break on that.
Does child support wrap when they're 18, or is that a myth?
Generally, child support is payable until a child turns 18 years old and has graduated from high school. But if a parent can prove that a child, even though they're now an adult, is still a dependent, the court can continue child support. For example, if a child has an illness that precludes them from employment or handicaps them in some other way, that they cannot support themselves, and there is medical proof of that, then the court can order child support payments to continue into their 20s or 30s or even beyond. The program for calculating child support, is called the DissoMaster in California.
Do I have to pay spousal support if my ex remarries?
Spousal support is normally payable to the other spouse until they remarry or pass away. That, of course, depends on whether or not you're talking about temporary support or long-term support.
And can you talk a little bit to alimony? What factors determine it? And
Yes. So, as we discussed, alimony is of two types. There's temporary alimony or spousal support, and there is permanent alimony or spousal support. Temporary spousal support or alimony is basically there for a safety net purpose. In other words, once the parties break up, now instead of having one household expense, you have two household expenses. You got to pay rent over here and maybe a mortgage or rent over there. Because of that hardship, the courts use the DissoMaster to calculate spousal support. If you have been married 10 years or more, spousal support can be long-term. And long-term spousal support can be permanent for as long as a person lives. If it's less than 10 years, it'll be for half the time that you were married. Married for 8 years, you'll get long-term support for 6 years married, you'll get long-term support for 3. So those are two differences. Temporary support will be based on the calculation. Long-term support is based on a variety of factors, and you cannot use a DissoMaster for that calculation. You take into consideration the length of the marriage, the health of the parties, their standard of living, whether or not domestic violence occurred, and other factors to come up with an award to the supported party that can at best replicate the standard of living that they had during marriage.
do I need a prenup?
If you're going to get married and you have any question about whether you need a prenup, you probably need a prenup. So the prenups in California are often prepared by non-attorneys, and that is a huge mistake. You should have an attorney prepare a prenup for you. A prenuptial agreement is an agreement, a binding agreement between the parties about all the issues that come up in a divorce. Spousal support, property division. It cannot include child support or child custody. So if the parties, for example, want to waive the right to spousal support in the future, that has to be specifically included in a spousal support or a prenup agreement, pardon me. And in order to be binding, the parties each have to consult an attorney. If one side consults an attorney and the other side didn't, then that spousal support waiver may not be binding. It won't count. So you have to have both parties consult with an attorney and state so in the prenup agreement in order for it to be valid. Prenup agreements are subject to attack all the time. There's always the issue of unfairness. But there is the famous case of Barry Bonds, wherein he was right there at the church and all ready to say "I do," and right before his bride walked in, he gave her the prenup agreement, and she signed it. And the California court said it was a binding agreement. She signed. She had an attorney available, apparently, but if she had not had an attorney, that might have been questioned and subject to attack.
How can I protect my assets before marriage?
Yes. So if you have property before you get married
In the state of California.
in the state of California, and you're worried that you want to preserve them for your children or for somebody else, some elderly parents or other family members, and you want to protect them, then before marriage, you should get a prenuptial agreement. It's a binding contract if it's done right, and will protect your property so that, in fact, the community property laws would not apply to you if both sides knowingly waive that right.
What are my rights if I marry without a prenup?
If you marry without a prenup, then you have the standard rights of community property, which is 50-50. And all the other things that go with it. You have the right to spouse support. You may also have the obligation of spouse support if it turns out you don't have a prenup and you make more money than the other side.
Can we create a postnuptial agreement after marriage?
Yes, you can, and however, that is much more limited and difficult to enforce. The courts generally look upon those kind of agreements and presume that there was some sort of coercion or duress involved. And so you have to take a lot of steps to prove that this is truly voluntary.
Let's talk domestic violence and restraining orders. How can I get a restraining order?
So domestic violence restraining orders in California basically apply to anyone who is in a marriage, a dating relationship, or some similar type of relationship, as opposed to a civil restraining order wherein the parties are not family members, maybe co-workers or something like that. So in domestic violence restraining orders, you have to establish some sort of relationship. You have a child together, you were dating or whatever, and you have to prove that the other party has committed domestic violence on you. Now, domestic violence can take many forms. It can be actual physical abuse. It can involve other types of abuse, including verbal abuse. For example, stalking you or calling you 100 times a day, as far as the judges are concerned, is domestic violence. You need to file a request with the court, and you may get a temporary order, or the judge may not grant all the orders, just maybe some of the orders, and then we'll set it for a hearing on a permanent order, which normally lasts for 3 to 5 years, although you can get extensions on that afterwards based on the circumstances. You basically have to file your request with the court. The court will determine whether or not you get temporary orders and will give you a court date. You then serve it on the other side. They have a chance to respond. The court will set it for hearing. The parties show up, and the petitioner or the person asking for the domestic violence restraining order has the burden of proving that domestic violence did occur. The other side then has an opportunity to respond, and the court will make a decision about that.
This one reminded me a lot of the Betty Broderick case. Do you have, for lack of like a better term, I guess, like sort of a favorite, most fascinating divorce case you can sort of talk to?
Most fascinating divorce case. Well, they're all kind of interesting, of course. But I guess the one that comes to mind is the doctor who divorced his wife, who was an entrepreneur. And between the two of them, They ran a successful medical practice as well as a restaurant business and owned various properties and seemed to be doing real well. However, at the end of the day, the doctor ended up using uh, devices that were not permitted in the United States. He bought foreign devices for use in his clinic and was arrested for that, lost his license, had the business closed down, and now it's the wife that's making the only money that they have. And so that became a vicious battle because a doctor would eventually get his license back, but it was speculative as to when and what the value of that business was based on the fact that he had lost it due to an FBI sting. Nevertheless, it still had value, but calculating was very difficult to do. You have forensic accountants and those sort of types who will give you an estimate about the value of the business. Then, of course, there was the accounting process involved. And since the wife was the one that was making all the money, that was a big issue of accounting for her because she was taking in a lot of cash. And so there are people who can go in there and estimate how much cash you're taking. What they'll do is the expert will walk in on an average night and just look around and go to the cash register and count the receipts for that day. And based on what's collected that day and maybe another test day, come up with a projection of what the value of that business is. So that was a long and tortuous road involving law that at the point was not quite settled because there were deeds being passed back and forth. And so those kind of cases, can take years and even end up in appeal.
What about, okay, so without revealing any confidential client information, what is the most fascinating one you've ever worked on?
Well, there's all kinds that are fascinating, but I have one currently happening, and which I will not reveal the identity of the person. But in this situation, a young man and a woman were dating, and they were co-workers. And at some point, she became pregnant, and they lost two of their children. On the third time around, a baby was born. Now, during the relationship, the woman told the father that she was divorced and that she was living in the divorced husband's home with the divorced husband's brother. And so for that reason, he could not go to her house. So he believed her and accepted that. And so once the child was born, the father would have visits during the day, not overnight. And the visit would be with the family. And there were lots of family gatherings. This was a very loved baby by the father's family. Of course, unbeknownst to him, she actually was married and was having a relationship while still married to her husband. So at some point, the father learns that the woman is talking to this other guy, which turns out to be her husband, and backs out of the relationship. And so she starts cutting back time. And once the father decides that he wants to get a place of his own to live and seek more additional time, the mother just cut him off. He filed a paternity petition asking for part-time custody of his child. And the mother came back with a novel theory, which is actually long standard, but saying that he was not the father, that the real father was her husband, because under California law, the child was born during her marriage to another man, who was presumed then to be the father. Now, this is really based on the old laws where there was discrimination against bastard children, meaning, you were born and you didn't have a father. This is like a really old school type of law that still applies. So my client's prior attorney filed a request for a court date and was met with resistance by mom, who said, no, my husband is the one who's the father because the child was born during our marriage. We've taken care of the child. Basically, what she did was she shut dad out and said, we've been taking care of our son, who's only 3.5 years old, doesn't know his father anymore. And he was not on the birth certificate, and he did not ask for a DNA test. And the 2 years had passed on the DNA test. So you're out of luck. You can't prove you're the father. You cannot ask for a DNA test. And we're presumed to be the parents, not you.
That's a thing.
That's a thing. So his lawyer told him he lost. So he came to me. And I told him, that sounds like a bunch of malarkey. That doesn't make any sense. I mean, your sense of fairness, there's so many things wrong with it. So what I did was I filed a request with the court for visitation and to establish a paternity. And as it turns out, there are constitutional restrictions against that. A father and a child have a constitutional right to be with each other. That overdoes everything else. Also, the mother had been lying about the relationship that she had. And so in law, there's something called estoppel, meaning it's not fair for you to lean on this thing because you lied. That's what it's called. You're stopped from denying something because of this unfairness. And the judge, when I argued the estoppel issue in front of the judge or commissioner, she actually had no clue as to what that was, because estoppel is very common in commercial transactions, but it's rare in family law situations. So I told her it is a thing. I found case law regarding it, not in exactly the exact specific thing, but in situations where a father had tried to get involved and was precluded from doing that by the mother for one reason or another, deceiving him, physically preventing him, whatever it was. So I was able to get a DNA test for my client, who is the 99% father. And we are now in the third day of an evidentiary hearing, wherein I am presenting hundreds. I think I have 600 exhibits, which are photographs where the mother says, my client doesn't know the child, never spent time with the child. They're all pictures of the father with the child with his family, the father with the mother, and that sort of thing. So initially, she came out with, he wasn't involved with me, we hardly knew each other, the kid doesn't know him. Now it turns out they had 3 children, only one that survived. They had a long-term relationship. She hid the facts from him, and my client was very involved. And up until the time that she stopped the visitation, was a real father, to the point where on his knuckles, he has a name of the one kid that didn't survive and a picture of the baby on his back of his hand that didn't survive. So he is, in fact, a very devoted father. He's the real deal, and hopefully we'll be able to get this finished for him.
What are the steps to adopt a child?
Yeah, so for an adoption, generally the process involves filing a petition for adoption. You file that with the court. It usually goes through the children's court, and the children's court will order an assessment done of the family. So someone will go into your home and find out what your family is all about, what the household is like, and do an investigation about the child. They'll do a report for the judge, and you'll have to prove certain steps. It is not an easy process, and adoption can be a very difficult thing, because it depends on how your adoption is coming about. You know, for example, if you have an agreement with the birth parent, sometimes the birth parent wants to retain rights, and so it may be that they want to be able to see the child every so often. So birth parents can have strong rights if they exercise them. Mostly people think about adoption as being, hey, you got the kid, it's ours, that's the end of the story. It's usually not the end of the story if the birth parents are involved and want to be involved. Uh, that's why the investigation takes place. Always the court wants to know what's in best interest of the children. You have to be live scanned and make sure that you are a fit person to be a parent. And so that process can take, anywhere 6 months to a year. And we can handle that for you.
What's live scanning?
Live scan is when you have been given a security check, fingerprints, photographed, FBI, list, your rap sheet is what's often called, and that's sort of a background check, right?
And do they use like we use People Finder, right? But they would use, I guess that's just what it's called.
Yeah. So basically, you have to give notice to the biological parents. So if you know who they are, you have to send them notice, because unless their parental rights have been terminated by the court, which can happen. It's a whole other feature of the court. It's called the dependency court. So yes, so you need to send out a notice, and as long as you give out the proper notice, you're okay.
What is the difference between adoption and legal guardianship?
Okay, so a legal guardianship is a process whereby you are given the rights to care for a child. Legal guardianship can be over the child or over their finances, so you can have one or the other, or both. Whereas in adoption, you act as the parent, so you have full rights. In a guardianship, you have specific rights, and you have to be appointed as the guardian. If the child is 14 years old, they can sign off and say, yeah, I agree. Young children, younger than that, cannot agree to it, but they can still verbally agree and express that to the judge. It's pretty common for the courts to ask the children to be present in court so they can talk to them and see what's going on.
How common would you say? Because I'm just thinking, obviously my parents went through divorce, but they would not put us in court there if it's
right.
They're often very messy, right?
Yes. So most courtrooms, they don't want children in the courtroom. I can say that I remember being in front of a judge myself and being questioned by a judge who I'd never met. And it was this tall, old, white guy asking me what I wanted. And I was 16 years old. And I was the subject of a bitter custody battle. And that's the old school. They don't do that now. Now they want a minors counsel to meet with the children, get their confidence, get the background done, and make a report to the judge, or get a social worker to do a parental plan assessment. In guardianship, they want them there because the judge wants to just look at them and say, how are you guys doing? It's more common there. Now, of course, there's already a report done separately, but it's just something that judges like to do in LA County.
You guys probably get a lot of mix, but what would you say the ratio is for amicable versus messy divorces that you handle, per se?
Okay, so most divorces come in saying we can work it out. And that's not how it works. It ends up being when they start actually discussing who's going to keep the house, who's going to pay support, who's going to have the children. It turns out that the majority of cases are litigated. But there's various levels of litigation. I mean, there are some cases where the parents fight over something, but then they come to an agreement at the end of the day. And there are other parents. I had a case that I had to witness wherein the parents were fighting over which soccer league a young boy would go play in. The father was in Torrance and signed up the son at 11 o'clock that morning, and the mother was in Redondo Beach and she signed him up at 2 o'clock. And they actually had a court hearing involving the coaches, the leaders of each league, and then the AYSO itself was there, represented by O'Melveny and Myers. So it was like about $2,000 an hour worth of attorneys in that courtroom. The rest of us are all sitting around going, hey, we have important issues. We need money. My client needs support. We had to listen to this stuff. So, it depends on the parties. That's a ridiculous example, of course, but it actually did happen.
Wow. So you handle other cases other than divorce, right? But what would you say is the ratio coming in of divorce? Have you seen an upswing? Tell me all about it.
Yes. So for many years, I handled workers' compensation accidents, criminal defense, civil litigation, and I was not doing divorces. And a friend had suggested that I handle a few divorces. And after about 10 or 11 divorces, they're very routine for me because there's no jury involved. In civil litigation, I have jury trials or criminal cases. The end of the case is going to be a jury trial somewhere. There is no jury in family law. So, practically speaking, it's a much easier type of case law to handle.
Do you know what the kind of a brief list of what the requirements are to adopt a child?
Yeah, generally you have to be a fit parent, which is the term. So in other words, you are self-supporting, you are mentally and physically healthy, and that you're free of a criminal background more or less, and that you can prove that you're capable of taking care of children. That's the general overall.
With criminal background, run-ins with I feel like a lot of people have had run-ins with the law, right? So
yes.
how stringent?
Yes. So that goes back to the live scan process. And you always have a right to explain to the court why you used marijuana back in 1975, and that would now be totally irrelevant, today. Or that you had a bench warrant because you didn't pay traffic tickets or something, years ago, as opposed to being a major felon or being involved in a violent crime. So of course the court will look at the court tries to be practical and realistic in all cases, and be reasonable.
Can a father's name be removed or added to a birth certificate before or after the fact?
That is a difficult process to remove a father without his permission. And you have to have a darn good reason to remove his name from it. First of all, fathers in general have to sign an affidavit that they are the father in order to be put on the birth certificate in the first place. And that's the time for mom to object. So if you want to add a name, for example, father didn't put his name on at the beginning but wants to do it now, you can do that with a name change. And then you can add that to your birth certificate, of course.
What rights do unmarried parents have to children?
It's surprising. That issue comes up a lot, more than you think. And that's probably something you see a lot in the real estate area. So it often happens that the macho husband has got the work and he's bringing in all the money, and they purchase a house, him and his girlfriend, common law wife, we'll call her, although has no legal status in California. It doesn't matter how long she lives with the guy, she's not going to become his wife until they actually go and register and get a marriage. It may be that they purchase a house during the time together. And at some point in time, the guy says, you know what? I'm going to change models. I have a different lady. Get out. It's my house. So I'll get those people who come in. The wife will come in and say, "Man, we were like together 15 years, 20 years. We got like 5 kids together, and now he's throwing me out of the house." Well, first of all, she's not married, so she does not have rights as community property. Um, there is no, doesn't really matter how many years she lived with the guy or anything like that. She's just out of luck. You got to get married. However, there is the theory in California, promissory estoppel. If the husband said something like, I got the house, I'll pay for it, you take care of the kids, and we'll live together, and this is our home. And that's what was told to people, to friends. They get together at family party. Whose house? It's our house. It's our family house. In that case, he can be forced to share the house with you under the theory of promissory estoppel. In other words, he offered it to you, you agreed, and you acted on it. Instead of leaving and finding somebody else, you stayed with this guy. You raised his children. You made his meals. You cleaned his clothes. And so you can, you may be entitled to some sort of compensation. You have a better case if you were working during that time and helping with the household bills, so that it wasn't just him paying all the household stuff. It's an easier case if you were working and contributing that. But in any event, you do have rights.
With today's day and age dating, I don't know if you're aware, there's like different types of, especially because we're in California. We're probably gonna have to cut me on this. We're in California. There's so many different types of relationships. I'm not sure if you're familiar with like polyamory, but have you had any of those cases, or like, how does that complicate things? Are you familiar with any of those cases? Because once you get 2, 3, 4 people involved, right, it can be all agreements and
right. So that's an interesting subject, and it's not going to be any different than anything else.
Okay.
If you have an agreement, you have an agreement. The issue is going to be the issue is going to be whether you can enforce the agreement. Okay, so you're going to have to prove an agreement. Right. So the person that's holding on to this stuff in their name, they're always going to say, "We didn't have an agreement. You got nothing in writing." And the other person is going to have to say, "Yes, we did, and here's how I can prove it." Witnesses, monetary contributions. So, for example, if we're talking about a mortgage payment, just as an example, and that person can show money out of their account to the person on title's account, and then the mortgage payment is made, that could be proof. If you paid for some of the improvements to the property, you had air conditioning installed, you fixed the roof, and you paid for it, that would be more proof. So that actually should not be a deterrent, but it might not be a family law matter. Probably is not a family law matter. It sounds more like a civil law matter, because you're talking again about a contract.
Mm-hmm. Even if kids are involved and you got like 3 cooks in the kitchen.
The children would be involved in a paternity matter. Mm-hmm. But in that case, you normally only have 2 parents.
Right, but that sometimes you would have, well, I guess that they would only honor that, right? And that's sort of where the discrimination comes in right now, is like figuring that out. I think we're gonna see a more complex, I don't know, that's my guess.
Yes.
What do I know?
Yes, but you have to take this into consideration. Grandparents' rights, for example. Grandparents can have rights, but it depends. For example, if the father and the mother both agree that grandparents should not be seeing the child, that usually is sort of binding. Nothing the grandparent can do. If they are not together and can't agree on whether the grandparent can visit, the grandparent can have greater rights. So it depends on the policy of the law, which is to preserve the family unit, and how much evidence you have, how persuasive you can be. So these, marriages or relationships involving multiple persons. I'm sure that's coming, and I'm sure that's going to hit the courts sooner or later. But again, I think it's probably going to go the way of contract law. What's their agreement? With regards to children, that's different. What's in the best interest of the children?
That's great insight.
Yeah.
Lastly, are there any interesting new laws in the divorce space field that have come up that you want to talk to or mention?
Well, I think one of the main things that's happening right now is in the area of immigration. So what's happening is that parents are worried about leaving the country and leaving their children here. So there is a process or procedure whereby if the parents are deported and the children are stuck here, they can be given a special designation, and it's like a guardianship, an emergency guardianship, and they can be appointed guardians for these kids. And I'm sure there are going to be other things coming up, but that's one of the things that's happening right now. I've had people come into me, what are we going to do? I go, well, there's always this, special procedure for, emergency guardianship if you need it. Here at the Gomez Law Firm, we can help you with your answers for any of these questions. Thank you.